Good day, everyone. My name is Natasha Cuttings, and today I will be guiding you through the process of drafting a credit agreement that complies with the National Credit Act, or in abbreviation, the NCA. This presentation is designed to help you understand the key steps and considerations involved in creating a legally sound and consumer-friendly credit agreement. Before diving into the details, let me provide you with a brief overview of the scenario we will be working with today. So, Angelique Simmons has recently established a company named Payday Loans. Payday Loans specializes in providing short-term loans to consumers. I'm pleased to share that Angelique has received confirmation from the National Credit Regulator, or in abbreviation the NCR, that her application to be registered as a credit provider has been approved. This is a significant milestone for our business as it allows Payday Loans to operate legally within the framework set by the NCA. With that, the purpose of today's presentation is to outline the steps and considerations involved in drafting a credit agreement that meets the requirements of the National Credit Act. We will cover everything from understanding the NCA's objectives to the specific elements that must be included in the agreement. By the end of this presentation, you will have a clear roadmap for creating a compliant and effective credit agreement for businesses such as Payday Loans. So now that we have an introduction and overview of the scenario, let's delve into the National Credit Act, or in abbreviation the NCA, and understand its key provisions relevant to credit agreements. So, the National Credit Act is designed to promote a fair, transparent, and non-discriminatory marketplace for consumer credit. Here are some of the key provisions that are particularly relevant when drafting a credit agreement. Firstly, from Section 92, the pre-agreement disclosure. The National Credit Act in this section states, before entering into a credit agreement, the credit provider must provide the consumer with a pre-agreement statement and quotation. This ensures that the consumer is fully informed about the terms and costs associated with the credit. Moving on to number 2, which states from Section 93, form of credit agreement, the credit agreement must be in a prescribed form or a form that meets the National Credit Act requirements. This includes clear and understandable language, ensuring that the consumer can easily comprehend the terms. Moving on to key provision number 3, interest and fees from Section 101. The National Credit Act regulates the types of fees and interest that can be charged. This includes fees such as principal debt, initiation fee, service fee, interest, credit insurance, default administration charges, and collection costs. All these types of charges must be transparent within the limits set by the National Credit Act. From Chapter 4 of your consumer rights, consumers do have several rights under the National Credit Act, including the right to apply for credit and for protection against discrimination, and the right to receive information in a plain and understandable language. These rights must be upheld in the credit agreement, and these rights must be respected. Lastly, in Section 80, we speak about reckless credit. The National Credit Act prohibits reckless credit granting. This means that credit providers must conduct a thorough assessment of the consumer's ability to repay the credit before entering into an agreement. Failure to do so can result in the credit agreement being declared reckless and unenforceable. Now, compliance with the National Credit Act is crucial for several reasons. Firstly, legal compliance. First and foremost, compliance ensures that businesses or companies such as payday loans can operate within the legal framework set by the National Credit Act. This helps avoid legal penalties and sanctions that can arise from non-compliance. Secondly, relating to consumer protection, the National Credit Act is designed to protect consumers from unfair practices and ensure they are fully informed about their credit agreements. By complying with the National Credit Act, companies such as Payday Loans can build trust and credibility with its customers. Thirdly, speaking to reputation management, operating in compliance with the National Credit Act enhances the reputation of payday loans. It demonstrates a commitment to ethical business practices and responsible lending, which can attract more customers and foster long-term relationships. Lastly, risk mitigation. Compliance with the National Credit Act helps mitigate risks associated with credit acts, such as the risk of default and the granting of reckless credit. This ensures the financial stability and sustainability of companies such as payday loans. With a clear understanding of the National Credit Act and its importance, let's move on to the key components that must be included in a credit agreement to ensure compliance. Now, we should have a clear and solid understanding of the National Credit Act. Here, we will move on to practical aspects of drafting a compliant credit agreement. A credit agreement under the National Credit Act must have several essential components to ensure transparency and fairness. Here we have 8 key elements. Component number 1, parties to the agreement. This component or key element will normally be situated in your very beginning of your credit agreement. Here, you will have to clearly identify the credit provider and the consumer, including their full names, addresses, and contact details. Essential component number 2 is pre-agreement disclosure. Include a section that confirms the consumer has received the pre-agreement statement and quotation as required by Section 92 of the NCA. Our third component, principal debt and interest rates. Specify the principal amount of the loan and the interest rate. The interest rate must be expressed as an annual percentage rate and comply with the maximum rates prescribed by the National Credit Agreement. Fourth, speaking to repayment terms. Detail the repayment schedule, including the amount and frequency of payments, the due dates, and the total repayment period. Fourth, fees and charges. List all applicable fees and charges, such as your initiation fees, service fees, and any other costs associated with the credit agreement. Sixth, speaking to consumer rights. Outline the consumer's rights under the National Credit Act, including the right to apply for credit, protection against discrimination, and the right to receive information in a plain language. Seventh, relating to default and collection. Describe the actions that will be taken in the event of default, including any default charges and the process for debt collection. And lastly, relating to termination and rescission. Include clauses that explain the conditions under which the agreement can be terminated or rescinded by either party. To ensure compliance with the National Credit Act, certain specific clauses must be included in the credit agreement, such as your interest rate clause, your repayment terms clause, consumer rights clause, default and collection clause, and lastly your termination clause. Let's look at an example template to have a better understanding of which specific clauses must be included in your credit agreement. Here is a simplified template of a compliant credit agreement with the specific clauses that must be included. Number 1, your interest rate clause will read something similar or equivalent to. The interest rate applicable to this credit agreement is 15% calculated annually. The rate is within the maximum prescribed by the National Credit Act. Secondly, the repayment terms clause will read something similar or equivalent to. The consumer agrees to repay the principal amount of 10,000 Rand in 12 monthly installments of 900 Rand each, starting on the 1st January 2023 and ending on the 1st December 2023. Payments are due on the first day of each month. Thirdly, your consumer rights clause will read something similar or equivalent to. The consumer has the right to receive information in plain and understandable language. The consumer also has the right to apply for credit and to be protected against unfair discrimination. Fourth, your default and collection clause will read something similar or equivalent to. In the event of default, the credit provider may charge a default administration fee of 200 Rand and initiate collection proceedings. The consumer will be responsible for any reasonable costs incurred during the collection process. And last, we look at our termination clause, will read something similar or equivalent to. The consumer may terminate this agreement at any time by paying the settlement amount, which includes the outstanding principal amount, interest amount, and any applicable fees. The credit provider may terminate the agreement if the consumer defaults on payments for 3 consecutive months. And that is your example of a credit agreement. Over here, we identify potential challenges that businesses such as payday loans might face when drafting the credit agreement. Pertaining to compliance with legal requirements, companies such as payday loans will have to ensure that their credit agreement adheres to all relevant sections of the National Credit Act of 2005. When there are any amendments or changes to law, companies such as payday loans will have to keep their credit agreements up to date. Pertaining to the complexity of terms, drafting terms that are legally sound has to be understandable to all consumers. The National Credit Act necessitates the balancing of legal jargon with plain language to avoid confusion. Pertaining to consumer understanding, companies such as payday loans will need to ensure that consumers fully understand their rights and obligations under the agreement. Lastly, companies such as payday loans will have to consider the diverse literacy levels and language preferences of their consumers. Solutions and best practices can be offered to combat and address these challenges. Pertaining to legal consultation, companies can regularly consult with legal experts to ensure compliance with the National Credit Act and other relevant laws. Companies can also make use of legal templates that are pre-approved for compliance. Pertaining to plain language, the credit agreements need to be drafted in plain, understandable language. Avoid unnecessary legal jargon. Companies should use clear headings, bullet points, and summaries to make the document more navigatable. For consumer education, companies can provide consumers with educational materials that explain the key terms and their implications. Additionally, companies can offer workshops or online resources to help consumers understand the credit agreements. And lastly, pertaining to the regular updates, companies will have to regularly review and revise the documents to ensure it remains relevant and compliant with the National Credit Act. Here, we discussed the critical importance of clear and transparent communication in drafting credit agreements. This aspect is foundational in building trust and fostering a positive relationship between the credit provider and the consumer. Moving to point number 1, building trust. Firstly, clear communication is essential for building trust. When companies such as Payday Loans as credit provider communicate transparently, it leads to a more positive and trustworthy relationship with their consumers. This kind of trust is the basis of any successful business relationship. Moving along to point number 2, reducing disputes. Next, transparency helps reduce disputes. By clearly stating terms and conditions, misunderstandings can be prevented and can ensure smoother transactions. This not only saves time but also builds a stronger, more cooperative environment. Moving to point number 3, empowering consumers. Thirdly, clear communication empowers consumers. When consumers fully understand their rights and obligations under the agreement, they are better equipped to manage the credit responsibly. This understanding and feeling fosters a sense of empowerment and accountability. Lastly, point number 4, legal protection. Finally, transparent credit agreements provide legal protection for both parties. Clearly defined terms reduce the risk of litigation, ensuring that both the credit provider and consumer are protected legally. Addressing these challenges with the suggested solutions and emphasizing clear communication allows Payday Loans and other companies to draft credit agreements that are both legally sound and consumer friendly. By doing so, they build trust, reduce disputes, empower consumers, and ensure legal protection for all. Let's summarize the key points of today's presentation. Understanding the National Credit Act. We discussed the importance of the National Credit Act in promoting a fair and transparent credit market and its specific provisions that apply to credit agreements. Moving to drafting the credit agreement, we highlighted the essential elements that must be included in the credit agreement to ensure compliance with the National Credit Act. And lastly, we identified potential challenges in drafting the agreement, such as legal compliance, complexity of terms, and consumer understanding, and offered solutions like legal consultation, plain language, and consumer education. Compliance with the National Credit Act is crucial for the success of companies such as Payday Loan. It not only ensures legal protection but also builds trust with consumers, reduces disputes, and empowers consumers to manage their credit responsibly. In closing, thank you for your attention. I invite any questions or further discussions on this topic. Your insights and queries are most valuable as compliant and consumer-friendly credit agreements can now be created.